Welcome to today's webinar, Confidential Data Access Issues for Auditors and Evaluators, brought to you by NCSL. It is now my pleasure to turn the floor over to Catherine Osterhaus. Ma'am, the floor is yours.
Good afternoon, everyone, and our apologies up front for the technical difficulties to get started here. My name is Catherine Osterhaus. I am the IT Audit Manager at the Kansas Legislative Division of Post-Audit. And there I am. I'd like to thank the National Conference of State Legislatures for funding, coordinating, and producing this webinar. I also want to thank the National Legislative Program Evaluation Society, one of the staff groups of NCSL, for co-sponsoring this event. We are glad to have you here today to hear about the challenges and issues we face with access to confidential data. And the NLPS Executive Committee has been discussing data access and data confidentiality for a while now. We do understand not all of the audit and evaluation shops have access to confidential data, and even with statutory access, audit and evaluation staff may be getting pushback that can result in reduced access, delays in doing the work, or worse. So in response to concerns involving insufficient access, the committee has worked to adopt the Data Access Principles document, and this document is meant to support member organizations that conduct the program evaluations or performance audits or reviews or studies or any other form of oversight on behalf of legislators. And we hope to publish this principles document in the very next future. But in the meantime, we wanted to conduct this webinar to get the conversation going and to share some of the issues and potential solutions. So to do that, we have three presenters from different parts of the nation for this webinar, and I'm pleased to introduce them next. First up, we have Dr. John Courtney. He is the Program Evaluation Manager from the New Mexico Legislative Finance Committee. Second up, we have Justin Stowe, the Deputy Post Auditor from Kansas Legislative Division of Post Audit. And third up, we will have Ted Booth, General Counsel from the Mississippi Legislative Peer Committee. A couple of housekeeping things before we get started with this webinar. This presentation is available to download during the webinar. It can be accessed via the media library, which is the play button in the upper right-hand corner next to the telephone. So we have set aside a few minutes. I'm not sure how the delay kind of impacts that, but we do have some time, hopefully, for some questions you might all have. And you can ask a question at any time by entering it into the chat box located in the lower left-hand side of the screen. And we will answer as many questions as we have during this time. So with that, and without further ado, I'd like to welcome all of our presenters and turn it over to John, who will lead off our discussion. John, take it away.
Thanks, Catherine. Good afternoon, everyone. Thanks for attending today. Access to confidential data can play an important role in evaluating the performance of government. I'll start things off by talking about my experience with data access here in New Mexico, where we've had good success obtaining and protecting confidential data. So to give you an overview of what I'll cover, we'll start with talking about our statutory authority, our process for educating LFC staff and agencies, strategies for avoiding and overcoming those two nasty hurdles we sometimes see in evaluations, delays and denials. Finally, I'll provide some ideas about what works and what doesn't. To start off, I'd like to talk about what our ultimate goal is when asking for data. What are we striving for? Overall, we're working to provide policymakers with good information so that they can make informed and important decisions and prioritize funding. But related to data access, we want to keep the agency in mind in that they should be well informed of our data protections. We should provide agencies with a comfort level in sharing data. And also keep in mind what's in it for the agency. In that, can we offer an analysis or data organization that would be mutually beneficial? Finally, it's our job to be minimally intrusive and provide adequate protections for data. Whenever possible, we shouldn't be asking for data that's publicly available or data that we're not going to end up using. That alone can be the difference between a collaborative project and a contentious project. So our agency here in New Mexico has pretty broad statutory authority for data. We are to receive any non-confidential data upon request. For confidential data, we have the power of subpoena, which we've only used once to my knowledge in the last 20 years or so. So our statutory authority is one of the few things that we educate both our staff and agencies on. We educate a lot of this information is shared with agencies in the entrance conference, as you might imagine. So one of the first things we do is we share a pamphlet on what to expect during your evaluation, which has the statutory citations in there. We also make it a point to explain that authority in detail in the entrance conference. Talk about agency resources if agencies have any concerns with resources, or any concerns in general around data sharing. The earlier we know that an agency might be hesitant to share data and why, the better, and the sooner we can start working on solutions. That gets to the need for setting up a really structured process for data requests. It's important to make expectations and procedures clear to avoid future delays in our experience. We found each one of these points to be a best practice, if you will, in obtaining data from agencies, including the use of a tracking form for requests with dates, point of contacts, notes, establishment of a timeline, establishment of one point of contact at the agency and one at the LFC for requests to avoid any confusion, and then also the establishment of the escalation process for delays or denials. So specific to confidential data, we're only asking for that type of information when it's absolutely necessary. A lot of this information is commonly protected by FERPA, HIPAA, cases sealed by law such as juvenile justice or adoption cases. There are other gray areas that we run into where we might agree to disagree on the confidential nature of data. But we do find that agencies are willing to cooperate almost all the time. Sometimes they will ask to enter into a memorandum of understanding with us detailing how data is going to be handled and what protections we'll offer. So when it comes to MOUs, if you're not familiar with an MOU, I define it here as a formal written agreement laying out expectations of two or more parties, in this case being us and one or more state agencies. We use these on a regular basis. If an agency starts showing concern around sharing data, we offer MOUs as a tool to address these concerns. There are a few advantages and disadvantages to using MOUs. Advantages are that they set out clear expectations for us and agencies. They ensure agencies understand all of our capabilities to protect data. And they also help to set precedent for future data requests. The biggest disadvantage is that the process can be pretty time-consuming. Anything involving legal review, I find, can be time-consuming. Also, if you disagree about the confidential nature of data but decide to enter into an MOU, you're setting a precedent of sorts for needing this tool every time you ask for those data in the future. I want to shift gears for a moment and talk about cases where MOUs aren't getting the job done for one reason or another, cases where we see delays or denials. For delays, there are a few best practices we follow that seem to help avoid these, and those include that formal data tracking sheet mentioned earlier with dates and notes, having good documentation of when you asked for things, whether it was in person or over email. We also encourage our staff to establish a presence at the agency and ask for information in person. We find that this can be really informative and lead to success. And we're kind of unique in New Mexico in that our budget shop is also housed with our program evaluation shop. So we can often use budget analysts to find out reasons for delays and reiterate those requests. Denials, I find denials come in three forms. The first are resource-related denials. The story here is that the agency can't provide the data as requested due to a lack of resources. We address that usually by offering to receive a larger data dump, do the work of merging ourselves, cleaning, do any work we can on our end. The second are denials based on concerns with confidentiality. The story there is that state or federal law doesn't allow sharing, and we're typically able to address these, as I mentioned before, with MOUs or maybe even finding a workaround with de-identification of data when possible. The third is that the data just don't exist. They don't collect it. We have a responsibility to do our due diligence on that to make sure that it's true before moving ahead, and there have been at least 2 cases where we found that agencies told us they didn't have the data, but in fact did, and were required to report those data for federal reporting purposes. So sometimes an agency is so big they don't even know what they might have. When all else fails, we do have an escalation process we cover in the entrance conference. If an agency doesn't respond in the required timeline, evaluators will notify management. And there are basically 4 escalation steps. The first is just a management inquiry to the agency, which just means I call the secretary or the director of that agency. And this tends to solve the problem 90% of the time. It's usually some sort of resolution that's needed from a miscommunication. And we find that that usually solves any issue. The other 10%, we have to move on to these other escalation steps. The next one being a formal meeting involving the agency secretary and the LFC director. The other 10% of the time, that solves the problem. We have other tools at our disposal which are listed below, process-related consequences and subpoenas of information. Again, we've only had to do that once in the last couple decades. So luckily we're able to solve things usually from those 2 escalation steps. So what are the takeaways? Here are some things that we found to be the most important points to remember when asking for data. What works and what doesn't. So what works is asking for data in person, always trying to put a face to the name, if you will. We find that if you go through calls or emails, you tend to see more passive-aggressive type of behavior. Finding out what data is available before the request is made. So looking at all sources and making sure that you're not asking for something that's already out there. It shows that you value the agency's time and resources. And again, nothing can put the brakes on an evaluation or audit quicker than asking for something that's already available. And then having an agency being focused on being solutions-based. Think of this as a negotiating strategy, if you will, redirecting the conversation from just a hard no with no alternative to coming up with a common goal that you can both work toward. What we find doesn't work is, again, relying on email or phone too much for requests. It's good for documentation, but again, you see more passive-aggressive behavior when you rely on those things too much. Asking for something that's already available. Escalating things too quickly or without good cause or threatening an agency tends to just shut things down. And then challenging whether or not something is confidential. That gets to that gray area, and in my experience, we found that even when we're right on this, and we have, we asked for some Head Start data a few years back and had the director of the Head Start agency, the federal agency, write us a letter saying that the data we were asking for wasn't confidential, but the Head Start providers still didn't want to provide it because they feared it was confidential. So we've learned from that and put our efforts into, again, coming up with a solution. Usually it's a memorandum of understanding so that all parties are comfortable sharing data. And that's all for my part. I'm really excited to hear from the next 2 presenters, and thank you again.
Well, thanks, John. This is Justin. Good afternoon, everyone. I'm deputy here at Legislative Post Audit in Kansas. And I'm going to be covering some of the similar topics that John has put in front of you. I'm excited to speak about this issue. I think it's an interesting balance, and I think John's presentation alluded to this as well, a balance between the privilege we have as auditors to access confidential information and our need to have access to some of that information on occasion to answer our audit questions, and trying to balance that privilege with the responsibilities that that type of access comes with, the confidentiality of that data, and then also kind of giving some thought to what we really need and how critical it is to accomplishing our project. So my presentation, again, looks a little bit similar to John's. I'm going to start just very briefly touch on statutory authority. I'm going to talk a little bit about how we make our access clear to our staff, and that's on both of those sides of that coin, the importance of making sure that we get what we ask for, but then also making sure that we do our due diligence to protect that information. Touch briefly then on how we communicate our access to our auditees, and then spend a little bit of time talking about handling denial, since that's always kind of a touchy issue, and I think can be something that we all have to negotiate from time to time and just share out in Kansas, hopefully for edification. So, getting started, I'm not going to spend a lot of time talking about Kansas's statutory authority because I realize that's not relevant to a lot of you specifically, but I think the point here is that we all need to have a very clear and robust understanding of exactly what our statutes allow us to see and what they don't. So in Kansas, I might point out, if you look at some of that information on my PowerPoint, you'll notice we have very strong statutory authority to access documents and files and records. It doesn't, however, give us access to people's opinions. So that although we can pretty much get anything from an agency that we're auditing that is in paper format or electronic format, that is some type of a written record, even including video surveillance and audio recordings, we can't compel agencies to let us talk to their staff or, for example, require them to respond to our surveys. So I think it's just really important for each and every state to have a very clear understanding of that access and what it does and doesn't allow, because almost for sure at some point in the audit process you will be challenged by your auditees. And so I think it behooves us all to have a very clear and nuanced understanding of those things. In terms of making our access for our staff, we do a number of things here at Post-Audit, and if any of you out there have any interest in any of these materials on the cover, I'm not going to give examples, but we're happy to share, and we're always stealing from other audit shops, so happy to do our part if there's anything of interest to you all. I'm going to touch on them very briefly. We have a training module that covers our confidential access, talks about our statutory authority, and then the responsibility that authority comes with. We, of course, have our staff sign confidentiality acknowledgments and acceptable use agreements to kind of get them in the frame of mind that working in this office, they will likely see information that a lot of folks won't, and that they need to be careful of that information and take it seriously and keep that confined to business purposes only, and nothing to do with personal curiosity, obviously. And then we also pair up all of our staff with a mentor who kind of makes sure that they understand kind of that's our culture here, that we have a lot of access to a lot of stuff, but that needs to be used very carefully in our audit projects. We also have a number of policies that lay that out. So we have some policies that talk about security clearances, which just define what type of information our staff can see by default. We have confidentiality policies that talk about how we collect, store, and use and delete any confidential information that we might acquire during an audit project. We have a federal data set policy that calls out some specific nuances of handling federally protected data sets, because a lot of those federally protected data sets like HIPAA have certain requirements to establish an MOU and to purge data after the project and some of those things. So we have a policy that kind of lays that out and makes our staff aware that the federal data sets have some additional strings attached often that we need to be aware of. And then, of course, the one that's most important, I think, for today is our denial of access policy, and I'll be covering that here in just a little bit. Kind of big picture, again, I'm not going to go through all these things, but you can see we have kind of throughout our entire process, front to back, various ways to remind and reinforce this idea that we do have access to information if we need it, making sure we communicate that clearly to our staff throughout all the stages, through our admin check-ins conferences, all the way to the very end where we wrap it up. We have some really robust process to make sure that we have flagged all confidential data so that we can appropriately remove it when our need for it is over. Let's switch over here then and talk just a little bit about how we make that access clear to auditees. And so, like probably many of you, we send out an audit startup letter at the beginning of a project, and so if we explain to them that we have access to confidential information, and better yet, if we know exactly what type of information that will be, we'll communicate that in the letter as well. On our entrance conference agenda, we include an item there to make sure that we cover the issue of confidential access and make sure that agencies know that we have strong statutory authority to collect those records and kind of discuss that and raise any concerns early in the process. We also have an auditee brochure and a data request letter that kind of iterate those same principles and ideas at various stages of our work. I've included a couple examples here. These are nothing really that outstanding in the sense of not really that unique, but just want to kind of show you some of the language. It includes some of that. It's a little difficult to see, but we try to kind of give a high-level explanation of our ability to look at this stuff and kind of how that works from the very get-go. And so we include that in our example startup letter. On our auditee brochure, again, the language is pretty small there. Just want to show we just have to kind of put throughout all of our different brochures and forms to keep this in front of the agencies that we're interacting with. I'm going to move then to the handling denials of access piece, and I'm going to start with what I denial. So this is when we have some auditors go in. They might be trying to collect some, let's say, personal health information from an agency, and the agency says, no, we will not turn those records over to you. Anytime that happens, we train our staff through all those various means that I described earlier to raise this red flag very, very quickly. And so we have a three-step process. The first is that we explain our access to our auditee, and kind of as John described, that typically resolves the issue. But if it doesn't, we then step back and we evaluate how important the records are to our audit objectives, and then we develop our response for that agency. So I'm going to take each of those in turn and delve into those just a little bit. The first step, and I think the one that probably a lot of us are familiar with, and probably the first step most of us take, is whenever we have a denial of access, we elevate that to the supervisor immediately and have the supervisor contact the auditee and just explain to them, look, state law gives us this access, here's our statutory citation. We've had numerous challenges to our access over the years, and Attorney General opinions almost always, if not always, have supported that access. So, take this to your bosses, take this to your general counsel, look this over, and then get back with us. And like I said, 90% of the time, that resolves the issue. But if it doesn't, that then gets elevated to the audit manager and our director here, the post auditor. At the point that just simply explaining our access hasn't fixed the question, we always like to take a step back then and ask ourselves, how significant is this information to our audit objectives, right? Because that's the real key here is, do we really need it? They don't want to give it to us. We have access, but can we live without it? Can we find, do we really have to press this issue? And of course, in making that decision, we are cognizant of the fact that we don't want to establish a pattern of being told no and having that stick. So we're aware of that as well. We have this long-term kind of goal of making sure that agencies know that when the auditors come calling, they have to give us the records that are relevant to our audit projects. But we also want to think about the significance of that information to our project objectives. So we've got kind of three categories: records that are significant but could also be maybe collected in some other way. Records that are significant, they're going to be helpful to answer an audit question, but they're not critical. And of course, records that are critical. And based on our evaluation of the significance, then we develop our response. And so that can include anything from negotiating with agency officials to convince them to provide that. That can include having our boss contact them, or requesting an opinion from the AG's office to help make sure that everyone's on the same page, that we do have that access. We can sometimes often negotiate with the third party. So in this case, if we're asking for PHI, they may say, hey, the feds won't let us, right? We would be happy to comply with your request, but the federal government just won't prohibit or allow that. And so we say, hey, give us the contact person at the federal agency, right? And let us get in contact and deal with them directly, because as we all know, a lot of those federal laws have audit clauses that allow auditors at the state level to see that information. So a lot of times they say, hey, just put us in touch with them and we'll work it out, and we'll let you know what their conclusion is, and copy everyone on that and make it kind of a robust and open process. And that's often helped us kind of clarify access in those ways. And then finally, the one that we're kind of loath to pursue, really haven't had to do but once in our entire agency's history, is to actually compel them. And there's a variety of ways we can do that. We actually have in our statutes, so our director can file a Class A misdemeanor. We can subpoena the records to our committee, and we can also ultimately suspend the agency's payments if they won't comply. I wanted to show you then the matrix that we use as we kind of think through that, which is, you can see the strategy, the importance of the information. Only at the critical stage do we get into the compel area, where we would actually take some more aggressive steps. In that final one that you see the footnote on, that's us suspending the agency's payments, and our director has decided he wouldn't do that unless the committee that governs our work has formally passed a motion supporting that type of action. So he's not going to step out on his own and exercise something that extreme. So just a kind of a framework for how we like to think about this and what we are and aren't willing to do. And one key point up there, of course, is we never want to threaten action that we're not really willing to take. So we want to be careful that we don't act as if we're going to do something and then back down. We want to be sure that we're willing to go as far as we say we are initially, and that we stick to our guns once that decision's made. Finally, I'm not going to spend a lot of time on this, of course, passive-aggressive responses. I think the key is, and we know all of these tricks, any of this has been auditing for a while, we've seen all of this and more. I think, again, the key here, however you come across these circumstances or whatever your potential response may be, you always want to think about it in terms of the importance of the information. We have to keep that in the forefront of our thinking at all times. And then a couple of final thoughts. I won't go again through all this to make sure we stay here on schedule, but a couple that I think are kind of interesting is just making sure we set the tone, the culture in our agency, that yes, we do have strong authority, yes, we should have the right to see this, but also a little bit of respect and consideration for our auditees and making sure that, as John mentioned, we're not too intrusive, that we're really considering how much we need the information, that we really think through our responses before we try to lay out an action plan if we're denied access. So with that, I will turn it over to Ted.
Okay, thank you so much, Justin. And it's a pleasure to be with you all today. I'm going to try to move pretty quickly through this since we had some delays in getting up and running on this. And much of what I do covers stuff that our previous two speakers have covered. And since I missed the practice session, I've asked the NCSL staff to take charge of advancing my slides. So if you would be so kind as to go to the next slide. Information access and training discussion today, and I'm Ted Booth, General Counsel. And the purpose of this discussion is to provide information on information access issues and to discuss strategies for resolving these access issues. Next slide. Access rights in Mississippi are controlled by statute, just as they are in the other agencies and other organizations like ours. I think every state is pretty unique in its authority. We have very, very broad authority in ours to receive any kind of budget file, any kind of financial information, statements, records, electronic files, you name it. I always tell our staff, since I'm general counsel, what this does is make files in the possession of agencies presumptively available to us. There will be some instances when they will not be available to us, and I'll explain to them things like attorney-client privilege and things like that. But generally speaking, we're going to have access to most files. Next slide. Now, most agencies we deal with are familiar with our authority. There are agencies we deal with in Mississippi on a daily basis. The Department of Health, the Division of Medicaid, the Department of Human Services, the control agencies like the State Auditor and the Personnel Board. These folks understand our authority. We have working relationships with us. We almost never have access issues with these agencies. Occasionally, a new mid-level manager will come in who won't understand us, but we will work through our problems, whatever problems we have with them, and generally to the satisfaction of all involved. Smaller agencies of state government are another matter, small regulatory boards. There are small regulatory boards that I've never visited, and I've been with the peer committee for 32 years. Local government entities, which are also under our jurisdiction, are sometimes a little difficult to deal with simply because they don't understand what we do for a living and why we do what we do. I found entrance letters set out our statutory rights of access pretty clearly and generally explain to people what we have a right to receive and what our legal authority is. And these matters are usually discussed in an entrance conference. Next slide, please. And some auditees become difficult to deal with regarding access, and reasons for this can include ignorance. As I say, some small agencies or small local government entities frankly don't quite understand what we do for a living, and they assume their information is theirs and they're not going to share it. Sometimes people will raise the argument that the information they are in possession of is not public information, and since it's not public information, we don't have a right to it. And I have to go through my long lawyerly song and dance with them to remind them that Mississippi's public records law was passed in 1983. Our law was passed 10 years prior to that and gave us access to all records and files, etc., in the possession of the agency, which pretty much made it clear that we had access to records, any records, before the public had any access to records under state law. That usually clears things up with them, although occasionally I have a person who is still remains recalcitrant. We also run into people who assert confidential status under federal law. We've talked about some of those things already, HIPAA and FERPA. Under state law, years ago when we passed a restrictive youth court act dealing with records of abuse and neglect, we chose not to adopt in statute the exception for state audit organizations reviewing the operations of Child Protective Services organizations. In those cases, those records were shielded from our review. Recently, we talked the legislature into amending the law, and we now have access to those. So that was a good example of a state law exception to our broad authority. And under federal law, of course, we as we've already mentioned from other speakers, FERPA and HIPAA provides some issues that we have to deal with regard to access. We do have to work carefully with agencies on those matters in order to allay concerns that they have. Many of their concerns are valid. They are responsible for keeping information confidential under federal law. They don't want to suffer sanctions. Next slide. Next. There we go. Yeah, so we try to anticipate problems. We are likely to discuss things like PHI and personally identifiable information in an entrance conference. In fact, I've been around long enough when I know we're having an entrance conference on, say, the Division of Medicaid, the Department of Human Services, the Department of Education. I know those issues are going to arise. I'm going to tell the project manager, I'm going with you, because invariably the agency will bring its lawyer to the meeting. I will take their lawyer aside, and we will work with them and try to come up with strategies for resolving these access issues before they create problems during field work. Next slide. And in most cases, these we can work out. In many instances, particularly in dealing with certain protected health information, blinded data can work. MOUs work. It takes a while to work them out. I've done enough MOUs with the General Counsel at the Division of Medicaid. Now we can usually knock one of those things out pretty quickly. They trust us now. We have not done anything irresponsible with their data. They've become very easy to work with in those instances, and I've discovered that they're willing to work with us on those sorts of things. However, there are some times when we do have some difficulty in dealing with people, and some of these strategies don't work. Next slide. Now, as I say, not all endings are peaceful. Escalation, if you can't work something out. If I can't go sit down with the agency's attorney and say, this is what we need to do, I think I can work with you on this, work with me. The next step is usually to kick it up to the executive director of our committee to go talk to the agency head. Project managers do not have the authority to escalate. It's easy to understand a project manager who's been in this job for a few years is delayed. He doesn't want to feel like he's failing. He might be a little concerned or angry with someone. We don't tell him it's his job to go say, we may subpoena you. Raising the word subpoena can really, really, really shut down all discussions, all what I would say peaceful deliberation between people, and it's best that no one other than the executive director use that word. Now, the executive director may end up using that word in a meeting with the agency's executive director. In fact, I have been along with the executive director before when he's had to raise that word, but that is something the person who sits in the director's chair is going to be able to raise, and no one else, because, to be honest, our executive director is the guy who's going to have to catch the flack for raising the issue of subpoenas. So he is the person who gets to bring up the use of a process to compel compliance with our request. Next slide. Recalcitrance, final thoughts. Thoughtful consideration of project needs and agency prerogatives should occur before you even think about using a subpoena. How important is it? It's going to really, really, really make people very, very cooperative if you use subpoenas. So you really need to decide, is it essential to use it? Does the denial of access strike at the heart of your project? Does it keep you from doing the project? As I've told people over here before, when we are preparing a subpoena, I can draft a subpoena ducis tecum to get files. I can draft a subpoena in personam to make witnesses appear and answer questions. I cannot subpoena cooperation. In fact, once the subpoenas go out, the cooperation disappears, and you're going to be left on your own to understand the 100 bankers boxes full of stuff that comes in. You're going to be left alone pretty much to try to figure out what the answers to the questions you have asked will be. So it is very, very important never, ever, ever to use a subpoena unless, one, it is the only resort, and the denial of access of information so strikes at the heart of your project that you may very well have to just shut it down if you can't get the information. Next slide. Now, passive-aggressive agencies. This problem can arise from time to time, and you have to just consider various strategies for dealing with the passive-aggressive staff. There are many of them. You can use in-house staff who are knowledgeable. We had a problem with our state personnel board some years ago. Some folks on their staff just were not being very cooperative. Well, we had several people on our staff who had once worked at the personnel board, and we have staff people who have been veterans of auditing the personnel board. So we actually were able to do a good job of going through and understanding their records, and we were able to bypass passive-aggressive staff there. Sometimes if you go to the agency director or some of the first supervisors of the people with whom you're having difficulty, they can help you work out the problems. So their passive-aggressive staff are often a problem. There are ways of working around them. Each project will yield its own possibilities in that area, and you just have to be sensitive to the various strategies that you can use to deal with passive-aggressive staffers. Next slide. Okay, staff training and access. Whenever an analyst comes to work for Peer, we give them a training module. And one of the requirements of the training module is that they drop by and visit with me. And I go over with them such things as committee jurisdiction, confidentiality requirements of staffing, and also the use of the subpoena and how we rarely use subpoenas in our organization, and how it's never the responsibility of the field staff to even mention the word subpoena, that really is a prerogative of the executive director. That ultimately, if there is a denial of access made in the field staff are supposed to come in, tell their supervisors about it so that we can discuss it during meeting and try to come up with a strategy for dealing with the denial of access. Next slide. Common strategies. We deal with MOUs regularly for dealing with PHI and PII. They generally provide a fairly quick resolution of the problem. When I say fairly quick, I know the Medicaid Council really well. I know the Department of Education Council well. I know the Department of Health Council very well. Those are the ones with whom we most often have problems regarding PII or PHI. We have a good working relationship. We can usually knock out an agreement pretty quickly. They have never been burned trusting us, and we can usually get an agreement signed pretty quickly, and we can work through that. We also build in a requirement with any kind of MOU that the agency will send its technical staff over to review our draft early before we even have an exit conference to review for any PHI or PII issues. We want to get those out of the way before we ever have to go deal with substantive issues in an exit conference. So we try to make sure those things are dealt with before the top-level managers come in and start complaining about the subject matter of the draft. Next slide. Sometimes redacted information is helpful. I don't like having things like Social Security numbers, for example, in my office. Sometimes we have to have them, but whenever we have them, we take on the responsibility of protecting them. So usually redaction is a solution when we're dealing with things like identifiers like Social Security numbers. We often don't have to have that information. And frankly, I'm just not one who wants to keep around anything here that we don't need, because if it is something protected and we have possession of it, we are responsible for protecting it too. And when records go off to storage, we're still responsible for them, even though we no longer have them in our possession. So I'd just as soon not have certain types of protected information in our office if we can avoid taking possession of it. Next slide. Now, sometimes a new strategy presents itself, and one should be open to the unique circumstances arising in each project. I'll tell you a quick story about a project we did a few years ago with a junior college foundation, or rather a senior college foundation. Support foundations for universities in the state of Mississippi have contractual relationships with their university. It's a way of giving the university some control over what the foundation does. The university agrees to provide office space and staffing and commodities and things like that in return, and also allows the foundation to use the university's good name. In return, the foundation raises money. We had a foundation that told us they weren't going to share any information with us, even though our law gives us access to the records and files of independent contractors where it's necessary to do a job. There were some questions about, under the unique circumstances here, whether we would be able to enforce our subpoena. So this was going on during the session, and I told my boss I have a strategy. We drafted some language for an appropriations bill which would make it clear that this university would no longer be authorized to expend any money under its control to pay the expenses of any foundation under any circumstances, period. The subcommittee chairman put it in the House bill. The House chairman brought it out, and it passed the House floor. And it's amazing how quickly their attitude changed. They called us the next day to pretty much beg on just how on whether or not we would please have that stuff removed from their bill, and what would they have to do to comply with us. So this is an example of just a new strategy that was developed to address a particular concern. Always be open to the possibilities of new strategies for dealing with denial of access issues or any other issue for that matter. And that's going to wrap me up, so I'm going to turn it back over to our moderator.
Thank you so much, Ted. All right, this is Catherine Osterhaus again, and I know we are reaching the top of our hour here. I do want to allow just a few more minutes for questions, realizing we have started late, so we'll probably extend to about 10 minutes after, depending on the question. So just going right into it, the first question came from Amber. Amber wanted to know what best practices are there for the retention of work papers containing confidential information, and how long your organization keeps this type of data. So if each of the if the presenters could speak to that question.
Sure. So this is John from New Mexico. We try to redact information almost upon receipt of the data whenever possible. So, for example, if we're trying to link records from a pre-K program to other education records through Social Security or name, we'll usually come up with a new unique identifier so that we can not have the confidential information out where it shouldn't be. We keep confidential information password protected on our drives, and we get rid of them usually upon completion of the project, if not sooner. We can usually, as I mentioned before, find a way where we can redact it ourselves at some point during the project where the identifying information is really no longer necessary for us. And that's usually covered in our MOU too with agencies as far as destruction of confidential records.
We do the same thing in Mississippi. Whenever we draft an MOU, we put in our duties and responsibilities with respect to protecting any PII or PHI that we may come into possession of. Usually it calls for destruction of any of that information within a reasonable time, say 36 months after completing a project. We do another type of job for the legislature. We do background checks for Senate confirmation, and we have to acquire all kinds of confidential information in the course of that sort of work. And right now we have retained all of the files for those reports going back about 40-some years, and they stay permanently locked up in some cabinets in the basement of our building. In fact, at some point I'm going to have to come up with a strategy for destroying some of that stuff. But generally, for the kind of stuff most of y'all are going to deal with, you can address it in an MOU.
This is Justin from Kansas. Not a lot to add to that discussion. One of our unique challenges here in Kansas, I'm sure several of you share this, is that we have public work papers. So after the release of our reports, we have to make those available. So we have to be cautious and careful at all times that any information that is coming as confidential, so we can segregate that within a work paper structure from the very beginning. And then in terms of, like many folks, we segregate that to the end project. We actually keep it for 3 years up through our peer review cycle, just in case that'd be something the peer review team would like to look at. And so that's kind of how we handle the archival. It sounds like Mississippi, we also maintain kind of a record of any MOUs tied to that data, so if there is a requirement to purge, we make sure we go and do that. And then one other kind of final thing, in terms of just the security of confidential information in general, we've taken a lot of steps in our office to develop a very robust and strong IT security program. So we do a lot of training, annual training on that. I have what I consider fairly strong. I think we have a fairly strong security stance here in general, and so I think that helps mitigate your risks. We take extra steps for confidential information like encrypted emails and, iReport flash drives and some things like that. But in general, we just have a strong enough security environment that I think we kind of act as if all the information we deal with is confidential to set that tone almost from the very beginning.
Great, thank you to all of you. I have another question here from Greg. To what extent have your offices used reporting of a scope limitation in the reports or the findings to help navigate those instances when you were not able to get the critical data that you needed to answer the question?
Yeah, I can remember. We've done that before in Mississippi. We were doing a review on our State Veterans Affairs Board, which operates some nursing homes. And at the time we commenced our review of that agency, a lawsuit was filed by one of the managers of the nursing home against the Veterans Affairs Board, making certain allegations about a breach of contract. Generally speaking, in Mississippi, whenever a lawsuit is filed dealing with a particular subject, we back away from getting involved in that. Well, we decided we could sever those issues from our review. We could go look at the general administration of the agency. So what we had to write in the project was a very tight scope limitation statement explaining what we were looking at and what we weren't. It wasn't because of a data access issue, but it was, well, essentially it was for a different reason, not confidentiality, but because of ongoing litigation. But yes, we've done that before, and it is, you know, you can do it.
How about the others? Anything to add on that, or should we move on?
And nothing. Go ahead.
This is Justin from Kansas. Sorry to interrupt you, John. Greg, that's an interesting question. I think in Kansas we have a lot of discretion over setting up our scope from the beginning. I mean, even though our committee directs the work, they really direct kind of the general audit objective, but we have a lot of flexibility internally then once the objective kind of gets approved to design that how we will. So I think our preference in Kansas, to the extent that we can, if we run into limitations in data that we think are going to significantly affect the scope, we try to rescope that and notify our committee that, hey, you know, that we're not going to promise something and then have to caveat, you know, a much more limited answer. We're just going to we're going to limit our scope intentionally to what we think we can answer. But inevitably, there are cases where we can't do that. And we use those scope limitations, and we've used it before. It always makes me a little bit nervous because I'm often afraid that the nuances of those scope limitations will get lost, you know, out in the press and the media and the committee hearings. But we have used them on occasion. I think that they are moderately successful. I think they might increase our risk as an audit shop a little whenever we have to do that.
And not much to add from New Mexico. I mean, in the example I used in my presentation on the on Head Start providers not being willing to share data with us, you know, that limited our scope in that project. But it spoke to a larger issue that that the legislature has been trying to take on for a few years now, which is, you know, for early childhood programs, you have a number of state-run programs, and then you also have federally run programs such as Head Start that states don't have a lot of control over. And so, you know, a question has been, how do we address that? How do we bring them into the fold as far as an early childhood system? So, you know, it's interesting. It was interesting in that the scope limitation and the lack of data access in that instance, you know, led to this bigger issue and was illustrative of a bigger problem that that the legislature identified with that program.
Great, thank you all. Maybe one last question to close this off. This is one of my pet peeves or interests from a perspective of redacted information. How do you ensure that heavily redacted information is not taken out of context by the audit team, or that redacted information is truly not relevant? If you could all speak to that a little bit.
Yeah, in New Mexico, you know, I think that is set up when we're figuring out what we need to ask for. So, if we can get away with asking for redacted information, and it doesn't set us up to a point where we would get confused or misinterpret data, we'll certainly do it. But there are instances where that just won't work for us. So it's kind of striking that balance and really figuring out what you absolutely need to ask for with us. And then, you know, once the information is redacted, there are a few more best practices that we follow so that individuals can't be identified later on, and they seem to be pretty commonly accepted principles for identifying information. So, for example, if you're talking about information from one county or one site, and you have less than 10 cases, it's not something that you report publicly, just because of the danger of potentially being able to decode, if you will, redacted information on the other end.
This is Justin for Kansas. I might just add, just personally, I don't think I would speak for the office necessarily here in Kansas, but personally, I don't like that idea of allowing redacted information to begin with, because it feels to me like it's kind of a half measure, right? Either we have access through state law to the information or we don't. For an agency to say, well, we will give you this information so long as only so long as we can remove the things we don't think you should be seeing, unless that information is clearly something we don't have access to through state law, which would be very, very unlikely. It feels like to me that's kind of, we haven't yet gotten on the same page with the audited entity, and I think even if we can make the redacted version work for our audit, it's likely to create problems down the road when there's this kind of fundamental disagreement with what we can see and what we have access to. So in my opinion, I'm not suggesting that receiving redacted information couldn't be a solution, but I would really, in my audit projects, try to limit that, because I feel like we haven't yet resolved a deeper and more fundamental question of what can we really see and what can't we see. And for our office, because that is so little, I'd want to get that resolved and really try to resolve that before I'd ever accept redacted information.
Well, that's the case with us. I mean, we would prefer not to use redacted information, but there are certain instances where we're going to have to. Listening to New Mexico discussing the issue of small data sets, not less than 10, I've run into that often with respect to educational information in FERPA. And I'm afraid the educational agencies have us over a barrel in those particular cases. We simply have to work with them on that and use the redacted information. But generally speaking, I'm going to prefer not to use redacted information, or at least we're going to limit the use of redacted information to instances wherein the agency just has a very, very, very strong legal argument for saying that that's the only kind of information we're going to get. And that's it.
All right. Thank you all for hanging out with us for the last hour or so. We are coming to the end of this webinar. Again, I want to thank all of our presenters, John, Ted, and Justin, for the presentation, as well as to NCSL and NLPS for sponsoring and co-sponsoring this event. And thank all of you who all joined us today. I know kind of these days and these weeks before Christmas are always hectic, and I do appreciate you hanging out with us. This webinar has been recorded. It will be available on the NESL website in about a week. And this concludes our webinar. Thank you all for joining us once again. Goodbye.